Who is your next witness, Captain?
Jonathan Zeller.
Jonathan Zeller, please. Good afternoon.
Good afternoon, sir.
Are you Jonathan Zeller?
I am, sir.
Welcome. Come on up here, sir. That's our witness stand. When you get there, you put your things down. You raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zeller. That's Z-E-L-L-E.
Spell your first name as well, sir.
Jonathan.
Thank you.
And that microphone will just up or down, but not back up.
Yes, sir.
Counsel, if you're ready, you may proceed.
Good afternoon.
I'm sorry. Can we approach very
Thank you. Anything else, Counsel?
No, Judge.
Bradley, if you're ready, you may proceed.
Yes. Okay. Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware from a company called Zeller. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrite systems?
I've taken a few. Each of them consisted of 40 hours of class training and exercises, and obviously the exam as well.
What about, have you taken training with the past team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know about the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10-06269, were you the lead detective?
I was not
What was your role in this case?
doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with the phone number attached to it of 772-713-9807?
Yes, yes.
Prior to coming to court today, did you have the opportunity to review the digital copy of that extraction?
I did.
Okay. I'm showing defense counsel what's been marked as states triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize this?
My initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state would request to move states triple P in as state 64.
Objection. Yes, sir. Name.
Sure. Objection to overrule, let it be admitted.
4. Thank you.
What's the next number?
64.
Thank you.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extraction consists or is done in order to obtain whatever is on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you would get also by doing that, you may get items that have been deleted, and so on and so forth. And that's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state referred to,
That's correct.
and you have not analyzed it.
No,
You don't know if there's any relevant evidence on it at all.
that's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know. You don't know who uses it.
I do not.
You don't know who it's registered to.
I do not.
Okay. One second. And as to any contents of that phone, you don't know if they're texts, who authored them.
Once again, I don't know the contents of it.
Okay. Okay, Your Honor, we'd like to come sidebar if you would. Sure.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, Mr. Demons. Demons, you need a restroom break? Need a restroom break? Nope. All right. Thank you. And what is it you all want to share with the cases?
Okay, Your Honor, and I can hand them up as I discussed. I don't think I left one with the court. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case. This is an app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to, as a foundation, establish that that technology is a reliable one, because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Demons, who she believes had the phone but has no proof of that to begin with, walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of the data. So that is our number one foundation argument.
The case that you want me to read?
Yes, sir.
I'm happy to take a look at it.
Thank you.
Yes, madam.
Here, I first start with citing back to State versus Maximate, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to Your Honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also in the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus Rigo, R-I-E-G-O. I just have a Westlaw site because it's 2022. It is not yet. This is 2022 Westlaw 175-46714. And again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them over.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile the articles and send them all back for your review while you're considering the issue, if you don't mind.
Sure. And the state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective, can stats and distances registered during walking and running be used as digital evidence. And I would direct your Honor's attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
Yeah. May I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted, and I have some of them. Send everything that I'm giving to His Honor a copy to you as well.
Okay.
Thank you. We're in recess.
Thank you, Judge. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taking 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication, or at least the expert, not even the method, and so we raised the Daubert issue. We gave notice of an expert. The state took issue with it, raised the Daubert objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Daubert objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Daubert situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Daubert question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon the technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step data. We've also made a relevancy objection to the fact that there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant, on a 403? How do we know that it's not, doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamell Demons. It was retrieved from Jameson Francois, not Jamell Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter of all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before. I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us, overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself,
Yeah.
that will be introduced through the
No, where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
And they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is and basically a Daubert issue on it. It's not clear. It's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what what is the 403 analysis, what's more prejudicial than probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something's more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
Just for process, Mr. Zeller, are you finished with your cross? Or do you have additional questions? Yes.
I don't think he has any relevant information. He said.
So you're finished?
Bring the jury.
Let me ask a few.
Jury entering.
Ladies and gentlemen, thank you. Sorry for the delay. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys. Ladies and gentlemen of the jury, all witness remains on the stand. So you have questions, counsel?
Yes, I have a few more, Your Honor. Thank you. You did, sir, 2 data dumps from the device in question.
I did 2 or 1.
You did 2 of them, did you not?
I did on this device, I did 1 extraction of it,
You only did it once?
if I recall.
Okay. Did you have the data verified by any third party for completeness of the download?
No.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes?
Okay, and you elected not to?
Correct, I did not do.
Did you have an engineer review any of the data that you retrieved?
No.
And have you validated that the Cellbrite extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got out of it. That's what the machine gave me, yes.
Okay, and how did you verify that the machine gave you a complete download?
I understand when you say a complete download.
You said you don't understand what I mean?
No, you can elaborate on that.
How did you verify that the machine, the Cellbrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can deal with.
Okay, so you can't verify.
I cannot, no.
Is there a process of maybe testing Is there another, first of all, software that you can use to download the information?
Sure, there's other software.
And you only use the Cellbrite?
Correct.
And if you used another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In theory, I guess so, yes.
In actuality.
All right, let's take it like that.
Okay. So when you say there's no way to do it, it is what it is, what you're saying is there is a way to do it, and you didn't do it.
If that's what you want to call it, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I have available to me.
Okay. So it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct, I did not do it, no.
Do you know anything about the testing of the technology of Cellbrite as to its efficiency and operability?
No, I don't. I'm not an engineer for them.
So you, pardon me?
I'm not an engineer for them.
Okay. So it would take an engineer to do that?
Or somebody from that company, not me.
Okay. So it's like any kind of software. If you have the software and it doesn't work in totality or it doesn't work completely, you're stuck with the answers.
I'm not understanding what you're trying to get at, but if you rephrase it one more time, I appreciate that.
If that Cellbrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay. Because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith. You're just having faith that the Cellbrite.
Sustained.
You are relying upon the accuracy and completeness of the Cellbrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes.
On Cellbrite?
Yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody, strike that. In the instances when you have downloaded information from a phone on using Cellbrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Cellbrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's the only reason that I would use it for.
Okay. Can I have one more, John?
Yes.
So it is your testimony, sir, that you didn't do an extraction from this phone in June. What year is this? And then another at a later date?
I don't
Or
recall.
at an earlier date in April?
I don't recall.
Well, you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th. of
February 28th. Okay.
2019, I think it is.
Okay. Nothing further. Thank you.
Counsel, is there a redirect?
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Celebrate is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection.
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Celebrate numerous times,
That's correct.
approximately how many?
Hundreds.
Have you found any instances in which Celebrate added data to a forensic download or that wasn't on the phone itself?
I'm sorry.
Objection.
What's the objection?
You would have no way of knowing that.
Overruled.
Can you ask it one more time? Sorry.
Have you ever had an instance in which Celebrate has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone. Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone and compare it against a Celebrate extraction?
Well, there's a couple things I could do. I could look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way of doing it, yes.
So I want to make sure I'm clear. Are you saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to use the original and to pretty much making a copy of the phone so that you don't ruin anything, delete anything, or compromise the device, or anything of that nature. So you work off that copy.
In terms of when the phone is brought to you, are there steps that are taken to make sure that there's no outside or internet or network access with the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was done?
This is called an advanced logical extraction. So,
What does that mean?
so there's different forms of extraction. The advanced logical pretty much gets, for the most part, I'm going to use the word everything on there. When I say everything, meaning the context, the pictures, the videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm
Do
sorry.
you need the passcode to the phone?
Yes, you do need the password, correct, yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, sir.
Thank you. You may step down. You're excused.
Thank you, sir.
Thank you.